Hi, Andrew Pfeiffer here from Pfeiffer Law again. We are continuing a video series that we've been doing on different aspects of probate administrations in Ohio. I did a three-part series earlier on the phases of a full administration probate proceeding in Ohio, including the initial filings phase, the inventory and appraisal phase, and the accounting phase. Full administrations in Summit County here in Ohio, which is $35,000 in assets or more, typically range from 10 months to a year. Now, what we want to talk about today is the creditor's claims period. The creditor's claims period is created by statute. Again, everything in probate is notice-driven and time-driven. So everybody who is a interested party needs to be given notice at each significant phase of the probate process, and any time periods that are set forth by statute need to be honored. So I want you to see that the creditor's claims period runs from the date of death of the decedent, right? So the first thing to understand is it's not about when things are filed with the court, and it's not even about when an executor would be appointed or a fiduciary would be appointed. The creditor's claims period runs from the date of death of the decedent. Now, because of the process and how long it takes to administer a full administration, almost always, if there are claims of the estate or debts of the estate, these are going to need to be presented to the fiduciary or the executor. Rarely speaking, we could have a final account filed, perhaps in an estate where we only had one asset and it was a liquid bank account or something like that. And then a creditor could still squeeze in and come forward within that 6-month period and present their claim directly to a beneficiary, but very rarely. Most often what we're seeing is creditors need to present their claims to a fiduciary after they've been appointed and within the 6-month period from date of death. And so this gives us flexibility. The law is designed to allow us to say, okay, if we know of debts, do we want to forego potentially opening an estate, filing the initial filings, and getting that executor appointed? Because that's what's going to start the ability for creditors to come forward and present their claim. The time period is already running. It's already being told because the decedent is passed. So really what we're looking at is where are we at within that 6-month period, and have the requirements been met for how the claim has to be presented appropriately to the fiduciary or to the court in order to preserve that claim. And if not, and that 6-month period runs and a claim is not presented timely and properly, it's forever barred. And so we are learning that we have flexibility. We have flexibility to make decisions that are going to be in the best interest of the estate. Thanks so much for learning about the creditor's claims period in Ohio and continuing to watch my probate series.